talk about mole. They're probably dying over there. Yeah. Good afternoon. This is Judge Elisa Perez presiding over the 210th District Court criminal docket for March 14th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Yes, Judge, top of page 20.
Okay.
Annex, may we have Crystal Herrera?
I think Mr. Shawala has like half our docket today. So welcome back.
Always happy to join you, Judge. And I am now hungry hearing about all this food. We had tacos today with the committee in Austin, and you can only imagine what tacos in Austin means.
No, and I wouldn't, I don't know. I'm not going to say, stay away from the mole, but kind of. Ms. Herrera, is that you? Yes. Let's get going, please.
In cause number 2023-0D0-0449 and 2023-0D0-0407 and 2023-0D0-0612 and 2022-0D0-0353. State of Texas versus Crystal Evelyn Herrera. Announcement of council, please.
Again, Elizalde for the state. State is ready.
Look, Shawala for Ms. Herrera, we're ready.
And Ms. Herrera is appearing remotely from the jail annex. We're scheduled for bond hearings on all of these cases. I believe this is one in which the court appointed you, Mr. Shawala, fairly recently. And these bond hearings, if I'm not mistaken, were already set by the public defender's office. So I appreciate you being able to step in quickly. If memory serves, Ms. Herrera was literally a week away from getting to trial when we had a new case come up, at least one, maybe two. So I show her at a total of $325,000 in bonds. Does that conform with what you have, Mr. Shawala?
That's correct, Judge.
Okay, you may proceed.
Thank you. Obviously, 325 is far beyond what my client can put together. It's going to assure that she remains incarcerated until we're able to try these cases or resolve them. She could potentially put together something in the $50,000 range. If you'd be inclined to do that, I'd ask you to go a hair under it. My understanding is that most bondsmen want collateral, a home or something at that point. But in terms of cash, you could potentially put together very close to $5,000. So that's what we're asking for, Judge. However, we want to split that up between the different cases. She does have a place to stay, that being 1708 Leroy Bonds. That's 79936. That's with her mom, Anita Melero. And, she has potential employment. She's worked for Checker Cab before. She'd be doing that again. She also may be eligible for SSI, which she cannot collect while she is in custody. She's not a flight risk, Judge. She's a lifelong El Paso resident. She's a U.S. citizen, doesn't have ties to anywhere else. And finally, Judge, I think some of the issues she has dealt with here have related to mental health issues. She does have a diagnosis of bipolar and depression and schizoaffective disorder. That is now being managed by medication. I spoke with her the other day. She's very lucid, and I think would be able to conform to whatever guidelines were you to put her on a split bond or something like that. And of course, I would expect that on the assaultive offenses, there would be orders that she stay away and that sort of thing. I've warned her about that, and she is totally fine with that, Judge. There's no concern there. I do believe that on those cases, non-process had been provided. If the state doesn't show that, I'll track them down, but I think the public defender's office put those together and tendered those. So we'd ask for a release on bond totaling, say, $49,999 or less.
Understood. Thank you, Ms. Elizalde.
Thank you, Judge. So I want to address, I do want to put on the record that cause number ending in 00612 is a BPU case, but I am covering for Mr. Munson. Additionally, opposing counsel mentioned something about non-pros. I know I have not, I don't believe I received one for the new one. And on the old case, we finally tracked down the CW. My understanding is they are cooperating. Of course, I don't have access to portal to confirm this, but that is my understanding of the case. Judge, I know you already know that we had an ag assault that was set for trial, and then she picked up these new cases, which is 2 drug cases. And then the most concerning one is the aggravated assault with the deadly weapon. Just briefly, Judge, officers were dispatched in reference to a kidnapping. Homeowners met with the officers and stated that CW had showed up at their house looking for help. CW stated that 5 days prior, the defendant, which was her girlfriend at the time, accused her of cheating and threw a vase at her. Defendant left the room and returned with brass knuckles and a sharp object attached to them and cut her on her left arm, and also placed a sharp object against her neck and threatened her. Later that day, the defendant got CW into the living room, pushed her onto the couch. Defendant then placed her knee on the CW's chest and pinned her against the couch. Defendant went to get bags and she saw her chance to escape. Went to the homeowners to ask for help, jumped and hid under their patio. Officers observed a small laceration along with fresh bruising on her arm, small scabbing on her neck, as well as bruising on her chest. So the facts are extremely concerning for the new case. They are different CWs on the 2 aggravated assaults with a deadly weapon. Your Honor, as to her history, we do have a prior pen trip theft that was enhanced 2 years. We have DWI dismissed in 08, a possession in 08, an AFV in 2010, possession in 14, theft in 15, what it looks like to be a battery from New Mexico in 2011. Your Honor, the state's position is this person is a danger to the community. She picked up new charges while being on bond, and our position is that the CWs, at least for now, we don't have anything saying they're not going to prosecute. So we are asking that, we are objecting to any modification of bond and PR bond.
Anything else, Mr. Shawala?
Well, Judge, just to add to that factual recitation, I want to highlight the fact that there's a delayed report. So these allegations were so, or this event was so traumatic that the complainant waited 5 days and only told the police about it because they happened to be there for some other reason. So I would hope the court would take that into account.
Okay, and I just want to confirm, I was asking the clerk if I have down 0449 being at 100,000, that because of the PR revo, the 0407 being 75,000 cash surety, 0612, I have that as 40,000. That's the one I wanted to make sure I had correct. And then the 2022 ag assault again was a PR revo at 100,000. Ms. Martinez, is that what you're showing?
Yes, Judge, that's correct.
Okay. All right. So then I don't think I can get where you want to be, Mr. Shawala, but I am going to reduce each of these bonds. In cause number 0449, that is going to be a 10,000 cash surety bond. So that's reduced. In 2023 0D00407, I'm going to split that bond. I'm not going to reduce it. It's going to be 50,000 cash surety, $25,000 PR, curfew, subject to testing, no contact with the complainant, report once a month. Let me see, subject to time, use no illegal drug or alcohol, no new offenses. Let me see. Are the complainants the same, Ms. Elizalde, in both the ag assaults?
No, Your Honor, they are different.
Okay, so no contact with either of the complainants in those 2 cases. So 50-25 split. In 2023 0D00612, I'm going to reduce that to a $10,000 cash surety bond. And in the cause number ending 353, it's going to be a 50-50 split with the same conditions as the 0407 case. It's not lost on me, so your client is aware, Mr. Shawala, that we had some issues, I think, leading up with that one ag assault, and the court was absolutely willing to work with Ms. Herrera in preparation for trial, and it was just very disheartening to see that, you know, on the eve of trial, we had these new cases come up, and that is the court's concern. She is set for trial in July of this year, and so we'll have our trial track on all of these cases. And if she doesn't bond out, obviously we'll address everything as we go along, but that'll be the bond order for the court.
I understand, Judge. And just in terms of my own preparation, do you know, or are we not ready to say yet which case will be the preferred trial? The oldest, or?
I would say we go with the oldest, although, yeah, because we do have one ag assault there. Yeah, I would definitely look at the ag assault before anything else, but I don't recall offhand anything that was either, I feel like we were at a plea. I don't know why I feel like we were at a plea. I don't feel like we were at a trial, but I could be misremembering. So just go with oldest for now.
I will
Yes,
say,
ma'am.
Mr. Shawala, that from my understanding is that the PD was gonna try to get an expert to testify. So I don't think we were at a plea, Judge, but that's.
Okay. I could be wrong. So we'll go to our next date, but I think we'll operate with that oldest first.
Thank you, Judge.
All right, thank you. Who's next? I
Bottom
think you're
of
next,
page
Mr.
22.
Shawala. 22.
And next, may we have Zamora, Sheldon Zamora?
On this one, I show is bonded 25,000. Is that right?
That's correct, Judge.
Everybody hear me? Then you can keep it down. Everybody's safe.
All right, go ahead.
In cause number
Thank you.
2023
Oh, sorry.
0D00536, State of Texas versus Sheldon Anthony Zamora. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alex Shawala for Mr. Zamora. We're ready.
And Mr. Zamora is appearing remotely from the jail annex set for a bond hearing. Mr. Shawala, you may proceed.
Thank you, Judge. His bond is at $25,000 cash or surety. He's been unable to post that. It's been in since February 5th. He has very limited resources, Judge. He works as a horse groomer at the Sunland Park racetrack. So he does have steady employment, but he has no savings. You know, it's kind of a paycheck to paycheck situation. I've spoken with his family. They could get close to maybe $750 together. And so we're looking for a bond of $7,500 or less. Would be happy to take PR or something like that if you consider it, but that's kind of the limit that he can reach there. This is a drug case, Judge. Sorry, someone's calling her. This is a drug case, so you know, on its face, it certainly doesn't present any community safety issues. He has a place to stay. It's actually with his employer there. They provide a room for him over at 1200 Futurity Drive. It is, of course, just on the other side of the state line there in New Mexico, Sunland Park. He's the U.S. citizen. He's been in El Paso since middle school, so he's not going anywhere, Judge. And we just asked for that reduction to the lowest level the court is comfortable going, so that he can deal with this case on the outside and continue to work.
All right, Ms. Elizalde.
Judge, he has no criminal record. However, he does have a pending criminal mischief and AFV out of the same incident. Briefly, Judge, officers were dispatched in reference to an AFV in progress. Officers heard yelling in the background. The defendant stated he got into an argument because his grandmother or mother wouldn't let him take his Xbox. The CW was trying to calm him down and he punched her. That's the basis for the AFV. He also punched a wall and the damage to car. The basis for the criminal mischief during the pat down, that's when they found, the baggie with crystal-like rocks came back, gross aggregate weight at 5.6 grams, and he admitted to having meth on him. Judge, we do have concerns for the victims in this case. As such, we would oppose modification or PR bond.
Okay. So I'm not seeing any other priors. I did see the two misdemeanors that are pending, and I did want to know if they were out of the same incident. So I'm going to go ahead and grant the request. It's going to be a full PR bond, 25,000 PR. He is to report once a month, subject to testing, curfew 10 p.m. to 6 a.m. unless he is working, which I can't imagine he works those hours. No new offenses. He will be allowed to reside in Sunland Park, New Mexico, but you may not change your place of residence without court permission. You're to have no offensive contact. I'm going to put down, I'm not really sure details on those other two related cases, but no offensive contact with the complainant or I don't know if he's having issues with grandma, but I don't want any offensive contact with grandma or any of family members either. And so that will be part of the PR conditions here, but it will be a full PR bond. And no new offenses if I didn't say that. Anything else?
Judge, if I may, Mr. Zamora, so you understand what's happening here. The judge is going to let you out, but you're going to have to report to the PR bond office. You should get instructions before you're released. If you don't report like you're supposed to, I am certain that Judge Perez will put you right back in jail. So whatever they tell you to do, you need to do, okay? If you have any questions, please call me, okay?
All right, thank you very
Thank
much.
you, Judge. May be excused.
I think you have one more, don't you? No?
Do I?
I don't know.
I hope
Microphone's
not.
done?
No, Judge,
Sorry, I really thought you had all the docket. See you later, Mr. Shawala.
If you want me to do anyone else's cases after this resounding success, I'll do them.
Have a good day. Go enjoy.
Thank you. You as well.
Bye-bye. Who's next?
Bye-bye.
bottom of page 18, Judge.
18. Okay.
Annex, may we have Barnes, Benjamin Barnes?
Yes, sir. Give me 1 second.
Okay, go ahead.
In cause number 2022-0D05778 and 2022-0D05178 and 2022-0D02121, State of Texas versus Benjamin Michael Mitchell Barnes. Announcement of council, please.
Eliana Elizalde for the state is ready.
Brian Kennedy for the defense is ready.
And Mr. Barnes is appearing remotely from the jail annex. We are scheduled in each of these cases for bond hearings. I again just want to confirm the bond amounts. I'm showing 5778 at being, is that 5,000 PR? Is he at 5,000 PR on that case, Ms. Martinez?
I'm sorry, Judge, can you give me that number again?
Sure, 2022 0D05778.
Yes, Judge, for the 5778, it's 5,000. For
Is it
five,
PR or is it cash surety?
if I'm correct, it's PR, but let me double check.
Okay, and then on 5178, I'm showing 5,000 cash surety. 2121, I'm showing 100,000, and that is a PR rebel. Mr. Kennedy, does that conform with what you have down for the bonds?
Yeah, I have the 100,000 as a cash surety. Is that correct, Your Honor?
That's what I'm showing. And in
Yes, Your Honor.
5178, I have 5,000 cash surety.
Yeah, I have a total of 105,000 cash.
Okay, so he's not he's not booked on 5778.
I pulled it and it was still a JMEG that may have just rolled over, Your Honor, but that's a PR bond.
Okay, so we're really just on 5178 and 2121.
Your
Okay,
Honor,
go ahead.
Mr. Barnes is going to be working with the GI Forum Outreach for Housing Healthcare Financial Assistance. Also, he can then have some treatment systems. He's been actively volunteering for trustee hours to prove his commitment. He does have a place to stay with a fellow vet, Julie Wyndham, at 5030 Joe Herrera Drive, who is alongside Ben contacts with the VA and is a resource to help guide him to the VA resources he needs. He has been in jail 227 days. He also was cooperative with a burglary investigation that went on. This was the big one. The 100,000 was a burglary of Hab, where there was supposedly his fingerprints on a car jack that was out by the gate. The items that were sold were not sold by my client. They have no evidence of him ever having possession of anything from the house. And we're asking that he get a PR bond so he can get out and start his move forward with the VA and the benefits of the VA and potentially seek some treatment.
Okay, Ms. Elizalde?
Thank you, Judge. As to his criminal record, I have a theft misdemeanor in 2019, an AFV in 2019, criminal trespass 2020, theft misdemeanor 2020, a federal offense, unknown dispo at this point. We do have a pending vehicle, and then the case is set for today. Just very briefly, Judge, on cause setting on 5178, the victim noticed a scooter was stolen from her backyard. It was pawned, and we do have statements from a co-defendant indicating that it was defendant who told him to do so. On the burglary of habitation, The CW is moving out and had items in trash bags located in the room near the back. Defendant damaged the door to get in and took 3 suitcases. And how do we tie him to this? There's a floor jack handle left at the scene. It had the defendant's print, so we got a match for that. Statements given to officers, I believe, was that Lupe took luggage bags. So the recommendation at this point is 2 TDC on the Burkhab and dismissal of the rest. My understanding has been rejected, but Judge, considering that he's facing the 2 TDC, that he has a history here, and very concerning that he's going around, and I'm told that he from Mr. Kennedy that he doesn't steal around, that he only hits cars, but that's not supported by the new charges or his record. So we would oppose a bond modification or PR bond, Judge.
So on, let me see. On 5178, I'm going to deny that bond reduction. I think 5,000 is appropriate. However, on 2121, I know we had a bond hearing on this one before. I'm comfortable going down on that one, so it'll go down to $5,000. No, I'm sorry, $15,000 cash surety from the 100,000. Okay. So I know he may not have the resources, Mr. Kennedy, but we are set for trial. I think those are your appropriate bonds in these cases. And of course, he's on PR on the other case. Okay.
Thank you very much, Your Honor. I appreciate it.
Take care. Thank you, Mr.
That's all I have. Can I be excused?
You may. Who's next?
The second one on page 19, Judge.
Mhm.
Annex, may we have Carrasco, Alexis?
So on this case, did we get the waiver to do it remotely?
First time I hear about that, Judge, but I'm kind of deaf and out of it all the time, so we have a new procedure.
So in order for us to conduct these pleas remotely, we need to have consent, written consent by both the state and the defense.
Is it a new requirement, Judge?
It is.
I want to know if I was sent that with the plea papers, I might have included there, but I didn't see them.
I am looking right now to see it exactly what I sent you, but I'm having a hard time finding that email.
And he's going to probation. I don't have a problem if you all can complete, but it requires his signature, so I don't know if the jail can accommodate that. I don't have a problem, Mr. Chacon, bringing him into the courtroom on Thursday.
Let me check real fast my calendar here. Thursday, the 16th. Thursday, damn it. Let's see. Calendar field full view. On the 16th, I've got 9 o'clock and a 9 o'clock, Judge.
Okay, so I can set you for 11. We'll set it for a plea at 11 in person, and we'll have your client transported.
Yes, Your Honor.
Okay, thank you very much.
May I be excused?
You may.
Thank you.
Okay, next.
Staying on page 19, Judge.
Mhm.
Annex, may we have Dominguez, Mark Dominguez?
Coming out.
And I just wanted to make sure also on Mr. Dominguez, I know it's a lesser included assault, but is that as to both counts?
My understanding is 1 count is being dismissed.
So count 1 plea, count 2 dismissal?
Yes, Judge.
Is that Mr. Dominguez? Mr. Dominguez, is that you?
Yes, ma'am.
Okay, all right, let's get going.
In cause number 2022-0D03571, State of Texas versus Mark Dominguez. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Dennis Moore for Mark Dominguez, ready to proceed, Your Honor.
And Mr. Dominguez is appearing remotely as well. Can we confirm, did we have the remote form on this one? I don't know if I checked it. Mr. Moore, did you all sign off on the consent, the waiver?
No, we didn't. We did the plea papers, and I don't recall. I think there might have been in the plea papers. I think there might have been a waiver of the in-person hearing.
Mhm. Let me go.
Oh no, we didn't sign an extra form.
So we're gonna bring Mr. Dominguez then back on Thursday as well. I mean, we need to have those. We're sending them out with the Zoom invite because it's fairly new. I gotta think maybe we can start sending those out, Ms. Elizalde, when we send the plea papers, because it's a new thing.
And I have been, Judge. I'm just wondering if these were a little bit older from when we got them.
They could-
But
Yeah.
it's priority, Judge. And I did email Mr. Huffman and Mr. Huffman and told him, hey, let me know if you're missing any of them for what I've recently sent out.
Okay, so Mr. Moore, this is one that I'm gonna bring back in person on Thursday at 11 a.m. as well.
Okay, Judge.
Okay, all right, we'll see you then.
Thank
Next.
Then on page 19, Judge.
Mhm.
Annex, may we have Fierro, Ray Fierro?
Yeah, this is gonna be another one. Did we get this one back?
Yes, Judge, I can forward it to you.
Okay, let's see.
I just got it this afternoon.
Okay, there it is, yeah. Give me 1 second, let me just sign off of it. All right. Okay,
In
Sorry
cause
about that.
number 2022-0D04838 and 2022-0D04436. State of Texas versus Ray Anthony Fierro. Announcement of council, please.
And Leonardo Alexander for the state is ready.
who's here on public defenders?
Mr. Hoffman. Mr. Hoffman, you there? Mr. Hoffman, are you there? Judge, we can go on to the next one on bottom of page 20.
Okay, we'll come back to you, Mr. Farrell, when your attorney gets here.
Okay.
Annex, may we have Marcus Hall?
Oh.
Go ahead.
In cause number 2020-0D01314 and 2019-0D02396 and 2021-0D00237, State of Texas versus Marcus Allen Hall. Announcement of council, please.
Leonardo Alexander for the state is ready.
John Williams for Marcus Hull. Judge, I would ask for some additional time to have a final plea deadline hearing. Portal has not been working since, I believe, last Thursday. I have issued some, or requested my process server issue some subpoenas, and we're waiting on that documentation.
Okay, and we were scheduled today for final hearing plea deadline. I do see that defense counsel has filed an unopposed motion for continuance. Ms. Elizalde, please refresh my memory. Is there a rec?
Judge, there is a recommendation. It's a 2 TDC for all the cases. I had put a time expiration of the 17th, I believe, for this 2 TDC rec. opposing counsel has asked for an extension until the end of the month. And knowing that there are portal issues, I talked to my chief about it, and we'll give it until the 24th, not until the end of the month, but till the 24th, Mr. Williams. Pending, see, how fast portal can get fixed and how fast I can answer the questions you raised for discovery. I think
Okay.
we can readdress later.
Okay.
So I'm going to reset your final hearing. I'm going to go ahead and grant that request for continuance and reset the final hearing plea deadline for April 25th. That will be at 3 p.m. With that, well, I mean, this one didn't have a trial date. We're going to have a trial date behind that. So it'll be the April 28th trial date.
Okay.
Okay, if you all need something in the interim, please let me know and we'll schedule you for hearing.
Thanks, Judge.
Appreciate it.
Well, can I be excused?
You may. Thank you, Mr. Hull.
Thank you.
Who's next?
Second on page 22, Judge.
Mhm.
Annex, may we have Rafael Silva?
Oh, he's not at the annex. He
Oh.
should be logged in if he's here.
Your Honor, I have him here in my office.
Oh, great. Okay, let's go ahead and just call it.
In cause number 2014-0D0-4998, State of Texas versus Rafael Valenzuela Silva. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Alyssa Nava on behalf of Mr. Silva, Your Honor, ready to proceed. Cynthia Caro with probation, Your Honor.
Okay, and we are set for a probation status hearing today. I don't know if you can move your camera, Ms. Gatto, just so I can get a visual, but I have received Ms. Nava updates. Hello, Mr. Silva.
Hi.
I've received, thank you, Ms. Gatto. I've received a very good reports. I've asked Ms. Gatto to, mostly because she's been so willing to do so. Some frequent reports on Mr. Silva's progress, and it looks like we're on track. And so I don't have another probation status hearing set, but Ms. Gatto, why don't you tell me, I know he's got some pretty intensive treatment and you're meeting with him weekly, is that right?
That's right, Your Honor. I am meeting with him weekly. He has a calendar, so he puts everything, all his appointments on his calendar. He started EHN services. Part of the EHN services with Takumi is that he is provided a caseworker that meets with him every single week. The caseworker has referred him for SSI benefits. So he's going to have a specialist that's going to help him specifically with that. Today, they helped them with food stamps application and Medicaid application.
Right.
So he's doing well. He knows that he has to stay at the rescue mission. He does not want to stay there, Your Honor. They're currently experiencing bed bugs. So I told him, did you tell him that there was bed bugs? And he said no. So I said, okay, well, then the first step is to try and fix the problem. So we're going to call after we're done with court to see if they maybe can change the mattress or do something to help him with that issue. He did ask his aunt if he can live with her. And he's just waiting for her to call him back and yes or no. I've told him that he cannot go anywhere without your permission. And that even if he's told that he can stay somewhere, he needs to let me know first and I let the court know and then he's allowed to live.
Okay, so that's concerning, but maybe there is some relief there with family. I was going to say, Ms. Nava, do you have anything?
No, Your Honor, I don't.
Okay, so I was going to say maybe because I am receiving, I guess, the informal weekly reports from Ms. Gatto, that maybe we would come back in 60 days, but I do want to square away maybe a better living situation for him. So yes, all of that instruction, absolutely correct, but we're going to come back in 30 days on a probation status hearing. Ms. Gatto, if you would just continue to give me the weekly updates and then we'll go from there. Okay?
Absolutely, Your Honor.
Thank you very much. Thank you, Ms. Nava. Nava, you're appointed. I'd say maybe stick around with us, maybe 2 more probation statuses and see how we're doing. Okay?
Absolutely, Your Honor.
Thank you, Ms. Nava. Mr. Silva, please continue to work with Ms. Gatto. She's given me nothing but good reports on your behalf. So I want to continue to see that. Okay?
Thank you.
Thank you, Mr. Silva. Take care. Thank you,
Thank
Ms.
you, Your Honor.
Caro.
May I be excused?
You may. Okay, who's next?
We also have Ms. Nava and Rafael Valenzuela, Judge.
Isn't that who we just did?
Oh, sorry, I apologize, Judge. I had him on the last name.
Uh-huh.
Okay. Going back to Mr. Rickman, Mr. Hoffman.
Okay.
And next, we have Mr. Fierro, Ray Fierro back.
I'm here, Your Honor.
Okay. Let's see, so Fiero. And that one, we did get the form. Okay, good.
Yes.
And Mr. Huffman, I think I appointed you on, or your office on one other case today, Alex Rodriguez.
Yes, ma'am. Debbie told me I'm kind of looking that case up.
Well, we can cover it. It's, yeah, we'll look at it. All right, Mr. Fiero, let's go. Mr. Marufo.
In cause number 2022-0D04838 and 2022-0D04436, State of Texas versus Ray Anthony Fierro. Announcement of council, please.
Eliana Elizalde for the state is ready.
Rick Hoffman on behalf of Mr. Fierro, we are ready.
Okay, Mr. Fierro is appearing remotely from the jail annex. Just want to confirm, Mr. Huffman, that you and your client consent to conduct this plea hearing remotely. Is that correct?
Yes, Your Honor.
And Ms. Elizalde, the state as well?
That's correct, Your Honor, yes.
Okay, Mr. Fierro, I have a written consent to perform this plea that we're scheduled for today via video conference. And I understand that although there are two cases, there's only a plea to one. That one is to the drug case. Well, they're both drug cases, 4436. Is that right?
That's correct, Judge.
Mr. Fierro, is that your understanding of what we're doing here today?
Yes, ma'am.
Okay, so let's get started. To do your plea, I need to swear you in. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Ray Anthony Fierro, May 24th, 1991.
Okay, in cause number 2022-0D04436, there are documents, the first of which is marked as State's Exhibit number 1. Those are the plea papers in that case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Fierro, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
Yes, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, I do.
Mr. Fierro, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
Not at all, Your Honor.
Mr. Fierro, have you ever been found incompetent, mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
Okay, so based on your testimony, your attorney's representation, and my observations of you, I am going to find that you are competent to enter your plea. Mr. Fierro, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso, Texas.
Okay, as I mentioned, in this case, you were charged by indictment with the 3rd-degree felony of possession of a controlled substance in penalty group 1 or 1B in an amount between 1 and 4 grams. Sir, to that charge, what is your plea, guilty or not guilty?
Not guilty?
Okay, so if you're saying not guilty, you're saying that you didn't do it. Is that what your plea is, Mr. Huffman? Have you talked to him about his?
So we went over the paperwork, I don't know, a week and a half ago. And yeah, I don't know if you want me to talk to him now, Judge. We signed a whole judicial confession.
Correct.
Admitting guilt.
So let me go ahead and put Mr. Fierro. I think, Mr. Huffman, you may have the remainder of the docket. So let me see who else is here. Or Mr. Stevens might have a case too. Let me go ahead and put this plea on hold, but I'm going to put him at the end of the docket so you all can have a breakout room to speak and then we can come back. So Mr. Fierro, we're going to come back to you, okay?
Okay.
Thank you. All right, who's next?
Page 21, Judge.
Mhm.
Annex, may we have Cypress Eve Ontiveros?
Okay, go ahead.
In cause number 2020-0D02251 and 2020-0D01332, State of Texas versus Cypress Eve Ontiveros. Announcement of council, please.
Eliana Elizalde for the state is ready.
Brett Stevens for Ms. Ontiveros, we're ready, Your Honor.
And Ms.
For the probation department. Good afternoon, Your Honor.
Good afternoon, sorry about that. And Ms. Ontiveros is appearing remotely from the jail annex. We're scheduled for bond hearings in both of these cases. She was on deferred, motions filed. Let me think. Have we conferenced this case before we get to the bond hearing?
No, we haven't, Judge.
Okay. So let me hear first from probation. I think I read the motion. She doesn't have any priors, is that right?
I don't believe so, Your Honor. Let me just double check.
Let me go back. I don't remember looking at the case summary on her, but I just remember looking it up. But we had significant non-compliance. Mr.
Yes,
Stevens. Mr. Stevens, what are you going to tell me? And I'm not necessarily talking just about the bond, but does probation have a recommendation?
Yes, Your Honor. Our recommendation is for her to be admonished for her non-compliance as being placed on probation and her case be extended for the number of months she absconded. Once supervision is regained, we are going to get her assessed by TAP for any level of treatment after being discharged unsuccessfully in 2021, and treatment to include possible participation in intensive supervision with a substance abuse caseload due to her still using drugs as recent as December 2022.
Okay, I misspoke. I did read that case summary. Is there a possibility to have her TAP screening done while she's in custody?
Yes, Your Honor. If you order it, I can get it done.
Okay, so I'm going to order that.
Okay.
So, Mr. Stevens, you want to proceed on your bond hearing?
Sure. Judge, might I also suggest that she be screened for the mental health unit? That might be, I do not know if she would qualify, but that may be, well, that could be a big part of the problem.
Okay, so if we can do both, Ms. Gaxiola, both the mental health screen, if that's possible while she's in custody, I think it is, and the TAP.
Yes, Your Honor.
So, Judge, Ms. Ontiveros is 28. She was born in El Paso. She's lived in El Paso since 2013. She moved to Fort Worth when she was 3, but she's back in El Paso after her mother passed away. If she's released, she has a place to live on Burgess with a friend. She has a GED. And as you said, she has no other arrest. She qualifies under 17.32 for presumption for a PR bond also. And I believe there's a 1622 in the file, or should be a 1622 in the file. I would show that, point out to the court that I did read the affidavit from the motion for the bench warrant, and it indicated the months she failed to report. But I would like to point out that a warrant was issued on February the 3rd of this year, and she was arrested on February 22nd. So she wasn't hard to find at all for the sheriff's department. So that's where we're at, Judge. She's been in jail now for 21 days.
So, okay. Anything else?
No, Your Honor.
Ms. Elizalde?
Judge, I have concerns given the significant non-compliance and the fact that she confessed to using marijuana, although she didn't confess others, and she wasn't providing UAs. I don't think she's demonstrated to the court that she's going to comply. I would ask for a TAP assessment, just like I think you're considering, Judge. And quite frankly, I was looking at a revocation if she's not at a point where she wants the help. And I think I can't tell if she wants the help or if she's going to take probation seriously as resources are being used. So right now I'm at a revocation, but I'll wait for the screening assessments.
Ms. Gaxiola, more or less, how quickly can we get both of those, the TAP and mental health screening taken care of?
Your Honor, I'd have to request an appointment through my supervisor first, and then a TAP counselor will be assigned. So I'm hoping within a month or so. I really couldn't give you an exact date just because I'd have to go through my supervisor first, and then it goes to the TAP supervisor.
Okay, Mr. Stevens, with respect to the bond, she's entitled to a bond, but based on your client's history of non-compliance, I really can't get very low. So it's going to be a $50,000 cash surety bond in each of these cases. And I'm going to reset her for a probation status hearing in 2 weeks because I want to follow up on both the TAP and the mental health screening. Where I am, Mr. Stevens, really is to get a handle on what the issue is here. Because if I look at her compliance or non-compliance, I was at Rebel, but when you look at the entire, I don't know that she's ever received any kind of treatment at any level, whether that's drug treatment. And I want to see what the TAP evaluation is going to see, what it's going to tell us, or how it can inform us better on what services will work best for her. So Ms. Gatziola, to the extent that we can do some type of expedited, I really want to move on Ms. Ontivero's case if she is willing to put in the effort for some treatment. That's where I am, even if it just means intensive with probation, Mr. Stevens. But the problem is I don't have anything telling me that. I look at the 1622, they didn't find anything. So that doesn't mean everything, but I'm just not at all comfortable with saying, well, you know, we let her out on a PR bond, say, you know, to comply with the conditions because we've lost her so many times. So that's where
We'll meet with her at the annex again, Judge, and then I'll also follow up with the probation department, and also our office will help create a plan as well.
Okay, sounds good. Then we will come back for a probation status hearing in 2 weeks. So that's March 28th at 3 p.m. And if we don't have any movement on any of the assessments, at least we can have an idea how quickly and keep the pedal to the metal there. Okay?
All right, thank you, Judge.
Thank you. Thank you, Ms. Ontiveros. Who's next?
Thank you, Judge. Have a great week.
You too. Thanks.
Staying on page 21. Annex, may we have Roacho, Joshua?
Wait out.
Yeah, I feel like I signed this one already, Mr. Marufo. I received it a couple of times. Let me see.
I wasn't sure, Judge, that's why.
I know, I think we might have gotten it. I thought I got one with Ms. Elizalde's signature, and then I received, let me double check. Yes, and I forwarded that. Actually, I forwarded it to Ms. Nieto, so let me forward it to Catherine. Okay. Sir, how do you say your last name?
Racho?
Racho? Okay,
Ram.
go ahead.
In cause number 2022-0D02638 and 2022-0D02640, State of Texas versus Joshua Raucho. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Brent Stevens, Mr. Racho, and we are ready as well.
And I do have and did receive the consent signed off by both the state and the defense and the defendant, Mr. Racho, to conduct this plea via video conference. Mr. Racho, is that your understanding? You're in agreement to do this over Zoom?
Yes, Your Honor.
Okay, so then let's get started. To do your pleas, I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Joshua Nathaniel Racho, 03/29/1999.
Mr. Racho, as I mentioned, so we have two cases here, but there are documents pertaining to each case, the first of which is marked as State's Exhibit number 1. Those are the plea papers for each of these cases. Within that document, you were guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Racho, do you recall reviewing State's Exhibit number 1 for each of these cases with your attorney and signing that document? I'm sorry?
Can you repeat that again?
Sure. Plea papers, State's Exhibit number 1 that list all the rights and the waivers of rights that I previously mentioned. Did you hear all of that?
Oh, yes, ma'am.
Okay. Do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Your Honor.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Stevens, have you had more than 10 days to prepare defenses in these cases?
We have, Your Honor.
And did you explain the plea papers to your client?
Yes, I did.
You believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
Yes, Your Honor.
Mr. Racho, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Stevens, any reason to believe your client is not presently competent to enter his pleas?
No, Your Honor.
Mr. Racho, have you ever been found mentally incompetent by any court?
No, ma'am.
Was that a no?
Yes, ma'am.
Okay, let me ask again because I'm having some trouble hearing you. Mr. Racho, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Sir, are you a U.S. citizen?
Yes, Your Honor.
Wait, where were you born?
Here in El Paso, Texas.
Okay. In cause number 2022-0D02638, you are charged with the first-degree felony offense of burglary of habitation with the intention to commit another felony. Sir, to that charge, what is your plea? Guilty or not guilty?
Guilty.
In cause number 2022-0D02640, in count 1, you're charged with the first-degree felony offense of burglary of habitation with the intention to commit another felony. What is your plea? Guilty or not guilty?
Guilty.
And in in same cause number, but count 2, you're charged with the third-degree felony offense of assault, family violence, impeding breath or circulation. To that charge, what is your plea? Guilty or not guilty?
Guilty, Your Honor.
Are you making all of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Ms. Elizalde, would you summarize the evidence, please?
Yes, Judge, as to count, cause number ending in 2638, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 18th day of June 2022, and interior to the presentment to this indictment in County of El Paso, State of Texas, Joshua Racho, hereinafter referred to as defendant, paragraph A, did then and there with intent to commit a felony offense of robbery, enter a habitation without effective consent of Destiny Sandoval and owner thereof. Paragraph B, did then and there intentionally or knowingly enter a habitation without the effective consent of Destiny Sandoval, the owner thereof, and attempted to commit or committed the felony offense of robbery. As to count ending in 2640, had the case proceeded to trial, the state would have been able to present or prove beyond a reasonable doubt that on or about the 3rd day of June 2022 and interior to the presentment of this indictment in County of El Paso, State of Texas, Joshua Racho, hereinafter referred to as defendant, paragraph A, did then and there with intent to commit the felony offense of aggravated assault with a deadly weapon into a habitation without the effective consent of Destiny Sandoval, the owner thereof. And it is further presented that a deadly weapon, namely scissors, that in a manner of their use and intended use was capable of causing death and serious bodily injury, was used or exhibited during the commission of the charged offense, and that the defendant used and exhibited the deadly weapon. Paragraph B, did then and there intentionally or knowingly enter a habitation without the effective consent of Destiny Sandoval, the owner thereof, and attempted to commit or committed the felony offense of aggravated assault with a deadly weapon. And it is further presented that a deadly weapon, namely scissors, that in a manner of their use and intended use was capable of causing death and serious bodily injury, was used or exhibited during the commission of the charged offense, and that the defendant used and exhibited the deadly weapon. Finally, Judge, as to count 2, had the state proceeded to trial, the state would have been able to prove beyond a reasonable doubt that On or about the third day of June 2022 and anterior to the presentment of this indictment in County of El Paso, State of Texas, Joshua Rocho, hereinafter referred to as the defendant, did then and there intentionally, knowingly, and recklessly cause bodily injury to Destiny Sandoval, hereinafter styled the complainant, a member of the defendant's family, or a member of the defendant's household, or a person with whom the defendant has or has had a dating relationship, as described by the Texas Family Code, by intentionally, knowingly, and recklessly impeding the normal breathing or circulation of blood of the complainant by applying pressure to the throat or neck of the complainant. Your Honor, the state has provided what's marked as State's Exhibit 1 and 2 in each cause number, and we would ask that the court introduce those into the record at this time.
Mr. Stevens, any objection? You're muted. Yeah.
No objection, Your Honor.
States 1 and 2 are admitted in each case. What is the agreement?
Your Honor, the agreement is 10 years confinement supervision under the deferred adjudication provisions. We were asking for $1,000 fine, $1,000 probated, that the defendant performed 300 hours of community service, TAP, UABA, curfew, family violence finding, standard terms and conditions, and no contact with the CW. Additionally, the state has agreed to dismiss misdemeanor cases that Attorney Araceli Solis is in charge of. I am to confirm with her once the plea is completed, and she will reach out to the misdemeanor attorneys to dismiss those.
Okay. Mr. Stevens, is that your understanding of the plea agreement?
It is, Your Honor.
Mr. Rocho, is that your understanding as well?
Yes, Your Honor.
I understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal these cases except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the trial court certification of your right to appeal. It is a document that explains your appeal rights. Because these are plea bargained or negotiated cases, you do not have an automatic right of appeal. Mr. Rocho, do you recall reviewing the trial court certification with your attorney and signing those documents?
Yes, Your Honor.
Okay. Finally, on each of these cases, since the recommendation is deferred probation, do you recall reviewing the motion for deferred adjudication with your attorney and signing those documents?
Yes, Your Honor.
Mr. Stevens, have you explained to your client both the benefits and detriments of deferred adjudication?
Yes, we went over that in depth, Judge. I do not like accepting deferred on first degree felonies ever, but my client wants to take the deal despite the downside if he's ever adjudicated guilty, which he's looking at life in prison possibly as a maximum. So I explained that in detail to him, and he wants to proceed anyway.
And that is going to be my question, Mr. Rocho. Do you understand that if you violate a condition of deferred adjudication, you can, the court can proceed to sentence you up to the full range of punishment for these offenses? In cause number 2638, range of punishment 5 to 99 or life. In count 1 in the other cause number, same range of punishment, and then 2 to 10 on the third degree felony. Do you understand that? That entire range of punishment is available to the court if at some point you are not in compliance with your probation and the court decides to revoke your probation. Do you understand that?
Yes, Your Honor, I understand.
And with that understanding, you're still asking the court to grant you deferred adjudication?
Yes, ma'am.
Okay, I will find in each of these cases that there is sufficient evidence to substantiate findings of guilt. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on community supervision in each of these cases pursuant to the plea agreement for a period of 10 years. There will be a $1,000 fine. The entirety of that fine is probated, which means that although as long as you are compliant with probation, you won't owe the entire fine. However, if you are somehow non-compliant, they can collect the entire fine. 300 hours of community service, screen for TAP, urine and breath analysis, curfew from 9 p.m. to 6 a.m. unless you are working or going to school. There is a family violence finding in cause number ending 2640. You are to have no contact with the complainants. And then I didn't have cause numbers, but I understand then you will have some dismissals forthcoming on misdemeanor cases. Is there anything further, Ms. Elizalde?
Nothing further from the state, Judge.
Mr. Stevens?
Judge, the only thing I would like to bring to the court's attention is my client in the near future is hoping to work in Pecos, Texas, possibly the oil fields. So for right now, he's planning to live in El Paso, but in the very near future, he's going to be approaching the court asking for a transfer in state for that purpose. At least I'm expecting that. So I wanted to bring that to your attention now.
Okay. Mr. Racho, the process is really simple in the sense that you need to notify probation as soon as you start seeing things potentially making your way outside of El Paso. Before you can do that, approach your probation officer, let them know so that they can provide me the details, and we can try and figure out a way to accommodate your probation. In other words, move your probation, but you can't do it without the court permission, okay? So make sure you're in good contact with your probation officer, okay? All right. Anything else?
No, Your Honor, thank you very much.
Okay, thank you. Good luck to you, Mr. Racho. Mr. Stevens, do you have anything else?
No, that's it, Judge. May I be excused?
You may. Take care.
No, you too.
Who's next?
Top of page 22, Judge.
Mhm.
Annex, may we have Alex Rodriguez?
Excuse me, sir, could you ask first?
Alex Rodriguez?
Show you right now. Please, 1901, and what? SUE. It's, I believe it's 7936, it's the first one, you bring me along.
In cause number 2017-0D03494, State of Texas versus Alex Rodriguez. Announcement of council, please.
Eliana Elizalde for the state is ready.
Rick Huffman on behalf of Mr. Rodriguez. We are ready, Your Honor.
Monica Lerma, adult probation, Your Honor. Good afternoon.
Good afternoon, and Mr. Rodriguez is appearing remotely from the jail annex. Mr. Rodriguez, just so you know, I went ahead because we were going to have this hearing and appointed the public defender's office to represent you, but that was literally right before we started our afternoon docket. So Mr. Huffman is with the public defender's office and he is representing you. But that said, that's why you haven't seen him. He hasn't spoken to you because I just appointed him. Okay, so we are here for a probation status hearing. He pled Ms. Lerma back in 2018 to 10 deferred. But this is one of these cases where we had really some serious non-compliance in terms of treatment. Now, with that said, let me see. We have the motion filed. With that said, I was focusing on the treatment angle. Where is it? Well, let me ask, what was the reason he wasn't compliant or consistent with his treatment?
Your Honor, there were a couple of reasons, mostly attendance or lack thereof. You know, he would go and then he wouldn't go. He'd cite having to work. He was I believe he was truck driving, so he wasn't there a lot of the time to attend treatment. But I do have those absences as the main reason for being dropped. He was dropped the first time September of 2020, and he incurred a balance of $400 at that time. He got back into treatment in February of 2021, when we started helping him with that fee. We started subsidizing him. And then somewhere around May 2022, he was dropped again for pretty much the same reasons. Wasn't completing assignments, wasn't presenting assignments, and then again the absences. Currently he's got a balance that 400 balance went down to 215, but that's where we are right now, the $215 balance, and that was accrued just based on those the absences that he incurs. When he doesn't show up, he's still being charged.
Yeah. So initially, I think scheduling was an issue. How does probation usually, do you have, you know, with this type of supervision, someone who's like a truck driver who's often out of town? I mean, I see here ultimately it was recommended that he find different employment. Sometimes that's a difficult thing to do. How does probation usually handle those scheduling issues?
Oh, we really work with them, Your Honor. They have to tell us, they have to keep in touch, let us know when they're in town so that we can bring them in, whether it's in a reporting period time or not, we'll see them.
So here's Mr. Huffman, this is kind of where I am with Mr. Rodriguez, and I totally cognizant that, you know, you haven't had the benefit of having talked to him. Is that it looks to me like probation, okay, so we had scheduling issues, he's bounced out of treatment, and then they come in, and whether it was a financial issue that was a concern, they took the lead there, and he still was non-compliant. So I want to revoke him. So I know you need to talk to him.
Yes, ma'am. I'll be out there shortly, Mr. Rodriguez.
Can I speak or no?
No, not right now.
What supervision is also reporting, this was kind of like the glimmer of hope, Mr. Huffman, was that, okay, so everything's outstanding, right? Everything's outstanding, payments, all kinds of things. And he was given permission to travel for work purposes. According to the therapist, it says he's near completion of treatment. So is that to say that all the times that he has participated, we're giving him credit for all of that?
That is, Your Honor. Whatever he presented did keep him moving a little bit forward. It was only the time that during those absences, when he was actually doing homeworks and stuff, that's my understanding.
Well, Mr. Huffman, what it says here is, you know, that although he was nearing completion of treatment, if he manages not to miss any more meetings and completes 2 to 3 assignments each week, he may get to where he can do the maintenance polygraph in 6 months. Okay. So he's going to do a jail commitment for his non-compliance. That's for sure. I'm going to give you a week, Mr. Huffman, to get out there and talk with him, knowing some of the details of what probation and his treatment therapist is saying. Aside from any type of revocation, I may consider a jail commitment, leaving the motion open, and checking in probably after 7 months to see if indeed he put forth the effort that the therapist is saying is possible for him to be on track. Okay?
Understood, Your Honor.
But leaving the motion open, because if he doesn't do it, I would definitely revoke him. Okay?
And if I may, Your Honor, just for the record, the department's recommendation is to admonish Mr. Rodriguez, keep him on probation, and there's also an issue that we would need to modify his conditions of probation, granting him permission to live with and or have supervised contact with his biological child.
Okay. So Mr. Huffman, after you meet with him, we can get into some more of those details if there's a request for a modification. But for my purposes, he's non-compliant. So we got to get over that first. Okay, we're going to reset him for 1 week, Mr. Huffman, so you can get with him. Ms. Lerma, thank you very much for the detailed report and your input today, okay?
Thank you, Your Honor. May I be excused?
You may. Thank you very much.
Thank you.
Who's next?
We just have Mr. Hoffman with
Mr. Fierro?
Yes.
Okay,